Every adult shareholder involved with a family business should have a lasting power of attorney for property and financial affairs. It's not just older people that need powers of attorney. What, for example, would happen if you had an accident or you weren't able to be at a particular meeting or make a decision? There may also be instances of some mental health issues, and obviously there may also be age-related conditions. So where you have directors of a family business, it is important to remember that a power of attorney isn't the document to use. Your memorandum and articles of association or shareholders agreement will govern how the director's incapacity might be dealt with. This incapacity risk as well as the death risk are two risks that you might not think about when you're doing your disaster recovery plan. You think about physical risks such as an IT failure or a fire or flood, but actually the risk of your people not being able to function is probably the biggest. In terms of the individual shareholders, the lasting power of attorney can enable decisions to be made by one person or by a group of people appointed as attorneys, either jointly or jointly and severally. In relation to trustees holding shares, it's important to remember that if a trustee lacks capacity, the rest of the trustees should be able to act without them, but that it is preferable for the trust deed to have something in it which provides for this eventuality. Where there's no power of attorney, it's important to remember that an ordinary power of attorney will not work when someone's lost capacity. So where there is no lasting power of attorney, it is the case that one has to make an application to the Court of Protection, and one would make that application to have a deputy appointed. And a deputy or deputies would have the same powers as an attorney, but they would be chosen by the court and they might not be the attorneys that the individual would have chosen for themselves. Where you don't have a lasting power of attorney and key decisions have to be made and a deputy has been appointed, it is still possible to carry on as before. It's important to remember that the deputy or indeed the attorney would be able to make decisions of a financial nature. They're not able to make health and welfare decisions. We often see families who have a policy covering this eventuality. For example, that if a deputy is going to be appointed, or indeed there's an inappropriate attorney, that there's some mechanism for example, for the family council to adjudicate on who would be an appropriate person to act. I think it's important for family business members to remember that there are also provisions in the Mental Capacity Act for health and welfare to be taken care of. So you can have a lasting power of attorney for property and financial decisions, but you can also have a lasting power of attorney for health and welfare. This isn't particularly pertinent to the business, but it will be relevant to the families that own those businesses. The health and welfare lasting power of attorney has been in place for some time. They're very valuable. They come into force only once the person has lost capacity, as long as they've been registered with the Office of the Public Guardian. It's also important to remember that there are life-sustaining treatment and end-of-life care provisions under the Mental Capacity Act. Within the lasting power of attorney for health and welfare, one can opt to have one's attorneys be given the authority to consent to or refuse life-sustaining treatment if that's required. You can opt out of that and instead have what's called an advance decision. These are sometimes known as living wills. That's how people in the press talk about them. And these advance decisions are a particular form of document which the individual can sign. It is effectively contractually binding on their medical team, whether in the NHS or the private sphere. And where the person is unlikely to recover from their illness and is no longer able to communicate what their wishes would be, they can direct what their care should be and what treatment they should receive, and the medical team are obliged to assist them along the lines of what that advance decision says.